My name is Jill Miller. I'm a trust and estates attorney. I've been practicing, I cannot believe it, for over 20 years. Okay, I have my own trust and estates law firm right down the street here, and I also am an adjunct professor of law at Fordham Law School, where I teach wills and trusts. I'm going to go this January on my 9th year. So don't worry, everybody, and the online viewers. I'm not going to be testing anybody at the end of this class. Actually, my goal for each one of you is that in 6 months' time, you're going to remember 3 things. That's it. Because I remember that I go to lots of seminars and you take down some great notes, but then, you know, in a couple weeks or a couple months, you don't remember anything that was said. So I'm hoping that you'll take away some 3 important points that you'll remember 6 months' time, and that'll impact your practice and what you do. And maybe since estate planning is for your family, maybe it might ring a bell that you can help your family at some point as well. And when I'm going through the lecture, as I highlight or I go over something that's more important, I'll bring it to your attention. I'll say, okay, maybe you might want to think about this as one of those 3 things. Now, the objective of this course is meant to cover the fundamentals. That's why it's titled The Associate's Guide. So we're going to start with the basics of estate planning, including discussing the basic set of estate planning documents for a client. I'm going to talk about one of my favorite things, my first day of class, the 2 ways to pass property at death. We'll go over and review intestacy and what it means to the family, discuss some basic estate tax considerations. We'll discuss the typical tax-efficient estate plan, and we're also going to review some important non-tax considerations. I actually, find that when I'm doing my estate planning meetings with folks, that, yes, a lot of people come to us, trust and estates attorneys, and I'm a tax lawyer, to minimize estate taxes, and that is important. But I will tell you that almost equally as important, and sometimes the clients will find it more important, to talk about those non-tax considerations. And you can really, in some cases, add value to the clients by talking about some of these non-tax considerations. So part of the package of materials that was sent to you, I want to quickly go through all of them. During the lecture, we're going to touch on some of them, but a lot of these materials is meant for you to use as a tool to adapt or refer to in your own practice and put your own personal stamp on it. So the first thing I'd like to bring to your attention is the estate planning booklet. And this booklet is something that I hand out to clients and colleagues in advance of our meeting. My goal is hopefully that the clients will get a chance to review some of the materials, and that way when we're going to go over the estate planning concepts, they'll be coming in with some basic foundation. And in the event that they don't, we have them, and during the meeting I'll go through some of the points in the estate planning booklet, and I'll say, okay, you can refer to this later. So here's about the tax-efficient will, or let's think about life insurance trust, or let's remind ourselves about the titling of assets, and then I'll go through the booklet and I'll circle the points for them to remember. Because these, the estate planning meetings, it can be really tough on some folks. You're going over some of the most stressful events folks can ever experience. So that's the estate planning booklet. One important note is that there's a chart in the back with the estate tax exemptions and rates. For the purposes of the booklet and for ease, I have the estate tax exemption amount at $5 million, even though it was indexed for inflation of $5,120,000, which we'll talk about in a moment, but that was just for ease of illustration. Okay. The next document I have here is the personal estate planning profile. Now, when we're going to be meeting with a client for their estate planning, we need to get an idea of what's going on with them, not only with their family, but with their assets. So this is a simple, one-sided, one-page snapshot that's meant to have the estimated assets of the clients with the liabilities, and also how it's titled. We're going to be going over that in a little bit, but the titling of assets is a very important part of coordinating your estate plan. So what I'm asking for the titling of assets is whose name is it in, especially when I'm focusing on a married couple. Is it in the husband's name alone? Is it in the wife's name alone? Is it joint? Okay, And if it isn't joint ownership, it could be if it's with husband and wife or with another party, maybe an adult child, what type of form of joint tenancy? Remember from law school the different types of joint tenancies, folks? Right? Yes? Okay. So tenants the entirety is for real estate between husband and wife. Tenants in common is different. How is it different? 1/2 undivided interest, okay? When we have tenancy of the entirety, that's a will substitute, which we'll go over in a moment, which passes by operational law to the survivor, kind of like without stop and go or collecting $200, it automatically goes. Whereas a tenant in common, it's a 1/2 undivided interest, which will be a probate asset, and we'll go through the probate process, okay? So we want to find about titling. Also, we want to find out about, we have a room here for life insurance, retirement accounts, beneficiaries. We want to make sure during our estate planning process that we touch base on the beneficiaries, okay? Is there a beneficiary, okay? Do we have a primary and a secondary, okay? Because these days, and we'll go over it in a little bit, so many of our assets are through will substitutes and have beneficiary designations. And for retirement accounts especially, there's tax considerations as well. And if you don't have a beneficiary on a retirement account, you can have unnecessary adverse tax consequences. And then on the bottom of the form, we have basic information about their children and grandchildren. Again, everybody should adapt it for what's good for them, but I personally like the one-sided one page because sometimes if you give too much to the client, it could be kind of obstacle of them, coming into the meeting like, oh no, I got to fill out this 3-page booklet, and oh, it's going to take me 3 hours, or so it's a one-sided one page meant for client ease. And then as you're going through it, if questions come up or you want to know more, you can ask and take that down. Very often with some of my clients, I'll say, you can fill it out, have your accountant fill it out, or have your financial advisor. Please feel free to attach sheets if you need it. Okay, so that's our estate planning organizer. Okay. The next paper is important persons in your estate plan, and the purpose of this is to send to clients in advance for them to have an idea of the key roles of an estate plan, so maybe they can have the arguments and the discussions and the thoughts about who those folks should be without maybe having a fight in your office, okay? It actually came out of, many years ago, a conversation with my old secretary where the client was going to come in and meet with me, and the client said, well, what do I need to prepare for? Questions do I need to answer? And then she came to see me, and we talked about it, and so here was the list was born. What's an executor? What's a trustee? What's a guardian? A healthcare agent? An attorney in fact for a power of attorney and successors. Meant to have easy to understand definitions for the regular person, not the lawyer, to understand the important roles, to hopefully come in prepared, because time means money, right? And plus, maybe it's one less fight in the office, right? So that's good. The last document that I have here, where we have the estate planning organizers given in the beginning. We have the important persons in your estate plan that's given in the beginning. This last document is meant at the end. It's the estate planning organizer, and it was actually just recently updated to become a little bit more modern to recognize all of our online world with passwords and PIN numbers and everybody doing their banking and brokerage and their lives online, and how important it is to have access to that information. So I typically give the estate planning organizer at the end. I like to be efficient and use the time in our meetings. So after I have all the estate planning documents executed, while my assistant is making the various copies, we take the time out to go over the estate planning organizer, which I hand out. And the first part is I explain to them, this is meant for them. It's not meant for me and for my firm. It has a lot of confidential and important information. And I've had a lot of positive feedback from clients that when they do use it, God forbid that there's an emergency, it's really, really very beneficial for the family. So the first page talks about how folks should organize their papers at home. Okay, and there's 2 categories: a fireproof box or safe deposit box, and a personal filing cabinet. And there's just a sample list of the different types of items that one may find in your personal filing cabinet and your safe deposit box, where the clients would use that list as a sample, hopefully follow them, and adapt as necessary. So with the thought being, okay, let your important people, know in your family who your named executor, your healthcare agent, and gosh forbid that there's an emergency, they will know where this is in the home. And so what I would say, okay, find it, put it in the back of your filing cabinet, or put it in your desk in a red envelope, or an envelope with marked index or organizer, so people could go to this first. And then on the list they could see, okay, here's what's here, and this is the order that it's in, okay? And the second part of our organizer is the important contacts. So in here is named the lawyer, the financial advisor, the children's school contact, your doctor, your insurance agent, your accountant, the guardian of your children, the executors of your will, co-signer of your safe deposit box. Also on the organizers, your burial instructions, the location of your will. I know traditionally many trust and estates attorneys will hold the original will in our vault for safekeeping. Cemetery plot or deed location, name, address, phone number, or any notes. Again, what's the idea? There's an emergency, they know who to contact, they know what's here, what order it's in, and being able to have easy access to the information. Half my business is estate administration, and there's always that proverbial client that comes in after the loved one is gone with those shopping bags full of papers, trying to look through everything, what is here, what isn't here. Again, organization makes things a lot easier for everybody. And the last page, and that's the one that I just updated for our modern online world, is possibly one of the more important parts. It's our important confidential information. Here I have all my passwords, PIN numbers, email accounts for the bank account, especially if some of us have different passwords to get into different accounts that we may have. So I have it all here. Again, if there's an emergency and the clients can't speak, since so many people do their world online, if you don't know what the password or PIN number is to get the statements, it can be pretty difficult, especially since some of us, or a lot of us now, are maybe opting for online statements, right? People opting for online statements. So you may not get the hard copies. The next seminar I'll be doing is the Estate Administration Associates Guide, and in that we kind of talk about getting prepared for our meeting with the lawyer to begin the estate administration process. And one of the things we always ask for is give me my date of death statements. That's going to be very important for the estimation of estate taxes, the size of the estate for the probate. So having the email, having the password for the email account or all of your brokerage and bank statements, really key, really, really key. So those are all of the documents. I will be referring to them at times, but when we go through the program, and we'll touch on a point, hopefully you'll be able to see how having some of these documents will relate to your practice and being able to make the estate planning process easier for the client and adding value for them. So, I always begin with what is estate planning? Okay, it's your money and more. Most people, maybe have this Hollywood version that, well, estate planning is only for the really wealthy, like the guy Thurston Howell III from Gilligan's Island with lots of money, but it isn't. It really is for everybody. It's a common misconception, and like I mentioned before, there are so many non-tax reasons that people will come where estate planning is very, very important. Say, for example, caring for disabled children. So if you have an adult disabled child and they're potentially going to be on Medicaid or SSI, even if the estate is a modest estate for tax purposes, if the disabled child is on Medicaid and SSI and they get an inheritance, that could potentially knock them off the benefits. So it's important to focus on that and make sure you have, under your state's law, a Medicaid exempt trust. Here in New York we call it a supplemental needs trust. So each state has their own way of doing that, a Medicaid exempt trust. So even if you have a modest client, that having a proper Medicaid exempt trust for the disabled child is worth its weight in gold. Also, the management of money, say for maybe a surviving spouse that isn't really good with paperwork. We all know those people out there, right? Yeah, sure, they don't want to look at any statements, and so that's a non-tax reason. If a person isn't necessarily used to working with financial management, having a trust maybe set up for them, even if it's not a large one, may be very important for them. Also, say you have minor children, okay? Again, it doesn't have to be tax reasons. Do we really want an 18-year-old person to have a fair amount of money? And what we may think is a lot of money may be very different from what they may think, or may think is what's a lot of money, and what we think is different. So what does that mean? If a young person, and I've seen this, maybe all of you maybe possibly have seen this, they get a lot of money early on, can really impact their decision making in a negative way, and maybe they make choices in their life that may not be best for them. I've seen a couple instances where parents get together and they're like, you know what, I don't want to have my child wait for us to be gone to enjoy some of the inheritance. Here, have some of a good chunk of the inheritance now. And this one particular situation, I remember he was doing really well, working very hard, got that chunk of money, quit his job, moved overseas, was a ski instructor, and then moved and went and surfed on the beach. And then after all that money was gone, 6 or 7 years later, decided to go join the working world. So maybe that may not have been the best. So also the modern family. So just what I mean by modern family is that I remember growing up and thinking of the Disney World version of the family, meaning it was like the same parents and 2 kids and a dog, right? Now, most families out there actually don't fit in that nice little Disney World Hollywood version. So just for our audience here, just kind of tell me, what percentage of families do you think makes up this idealistic Hollywood nuclear family of the same 2 parents with the 2 kids? Just raise your hand and give me an idea. Anybody?
30%.
30%, okay. 17. Anybody want to take a guess? 10%. Okay, well, at least you guys are all in the ballpark. It's 25%. Okay? But the way you would see the marketing growing up, you'd think it's like a lot larger, right? And most of our families are like that. But now that's no longer true. Multiple marriages, children from different relationships, single mothers by choice, same-sex relationships with children. Now we have same-sex marriage in some of our states. So all different types of families, and actually our original parents of the 2 kids actually a minority, only 25%. So our estate planning needs have adjusted, and it's important to realize that. Another important, the last important non-tax reason that I find that comes up quite often in my practice is the second marriage. And then the balancing of interests between the second marriage spouse and the children of the prior relationship. We want to have a risk, we want to reduce the risk of family discord, and there's a lot of conflict. Well, how do we take care of the spouse at the same time? We want to make sure that there's going to be money hopefully left over from the children of the prior marriage, because, and it makes it even more complicated if this second spouse has their own children, because, what do most parents do? They take care of their own blood. So there's that inherent conflict, and how do you tease out trying to balance the different interests? And we'll talk about that later. A Q-tip trust is one of the, which is a form of a marital trust that qualifies for the estate tax marital deduction. That is one of the common techniques, but we'll talk about that in a little bit. So our scope of estate planning, okay? It covers our expected distribution of money at death, but so much more. So incapacity as well. So normally as part of our estate planning meeting, we're going to talk about a power of attorney, a healthcare proxy, okay? End-of-life decisions, a living will. You're going to talk about guardianship of minors, the management of family assets, and asset protection planning. And that's actually a pretty important theme that I've picked up over the years. I call it, another part of it is the unintentional disinheritance. And what I mean by the unintentional disinheritance is that there's no conspiracy between people to disinherit certain folks or bad intentions. It's human nature or the way things just kind of fell out. Lack of thought, lack of careful planning very often can result in results that were unintended and really are very upsetting. I remember a couple years ago, maybe it's more many years ago, time just goes by faster as you're getting older, where I did a talk about estate planning of some of the rich and famous, and one of my favorite stories when I was researching was about Marilyn Monroe, and that most of her property, which right now is kind of like the intellectual property of the rights to her image and that sort of thing, is actually owned by strangers. People that she never knew in her entire life. And the reason why is that when she gave certain assets to people, if it's outright, they in turn can give it to their people and so on. So I remember that she had given a fair amount of bequests to like an old boyfriend or an old friend, and that person then turned around and got married. And then what do you do when you get married? You leave things to your spouse, and maybe then they had children. I just remember, reading about that. The majority of the assets that she has is held by people that she never even knew, and that means planning is very, very important, and to think about the what ifs. One of my real life examples I have is the lack of planning. There was a second marriage for both spouses, and he was stricken with a life-threatening illness, and he kind of just they went to I don't know if he did it himself, but it was a one-page special where I call it the simple I love you. Anybody familiar with that term? I love you. Everything to each other, and then on the surviving spouse's death, it'll go 50% to your kids and 50% to my kids. Okay, so he knew he was sick. He died, left everything to her. And what do you think one of the first things she did? Well, give her a couple weeks. She did a new will, and she changed the beneficiaries to who? Who do you think she would change it to? Not his children, to her own children. Actually, she did feel a little bad, and she did wind up giving them each $10,000, okay, which was at that point the the gift tax exemption amount of $10,000. But and then the children had called me up, oh, it's unfair, and what's going to happen? And I'm like, well, they made their choice. If you give it to somebody outright, it's theirs to do with what they want, okay? So how do we, again, this is a second marriage, children from a prior marriage. Here, instead, maybe a good solution would have been our marital trust, which we'll talk about later, the Q-tip trust. Instead of it all going outright for her to do whatever she wants with no obligation, it would go in a marital trust, support her for her life, and then on her death, whatever is not used up will go back to his children in the prior relationship, okay? Another example that I remember, I love those little examples to kind of add, some color to some of the things we're talking about. And one of the things I like about this example is that facially it appears okay. So the will was like this. So he left a second marriage, okay, children of prior relationship. Does a pretty straight up simple will. Names his spouse as the executor, which isn't what most people do generally when you're married for a long time. And then did a will, 1/3 to my spouse, my wife, and 1/3 to each of my children. Does that sound fair? That kind of sounds fair, right? 1/3 to the spouse, 1/3 to each of my children. I'm treating everybody equally, naming the spouse as the executor. We normally do that. Fast forward. Looks like it should be a third, a third, a third, right? You know what actually wound up happening at the end of the day? It wound up being pretty much 70% to her and 30% to the kids, approximately. And why is that? First of all, when we talked about beneficiary designation, we're going to go over that in more detail in a little bit. but the beneficiary designations was not coordinated with the estate plan. So he had a very large account, and that he put her as the beneficiary. So she collected it, and that does not get set off against her 1/3. Okay. 2, she's the executor. Most states, what executors get for all their pain and sweat and effort and also personal liability, that means your tushy's on the line if you do something wrong. What do they get for that? A commission. They get a commission. Okay? That's more money in her pocket. Okay? Now, state taxes. All the taxes were paid by the kids. Okay? Now, normally that's going to happen anyway, because if you have taxes that are attributable to the marital share, that could decrease the marital deduction and create more estate tax if there's a circular calculation, which goes beyond the scope of this lecture. But the bottom line is a will and a plan that seems kind of okay, right? Seems kind of fair, but because there was lack of real detailed thought, it wound up a result that wasn't intended. Okay. So again, one of my big takeaways, when I said about the 3 points, please make sure when you're doing your estate plan that you coordinate your assets with your will and your will substitutes, which leads us to our next part of our program, the distribution of assets on death. And there's 2 ways to do it. When I was growing up, my thought was always the Hollywood version. When you die, all of your assets are controlled by the will. And that there's an official reading of the will where there's this old stately gentleman in a wood-paneled room with a fireplace and all the beneficiaries sitting in chairs just like this in the front, and they have the will reading. And in fact, there is this great scene from The Rain Man where it's done just like that. And then instantly afterwards, when he got disinherited, he gets the car, you see him driving down the street in the car. Does that happen in real life? No, it does not, okay? Of all the years that I've been practicing, I've never had an official reading of the will, okay? It just doesn't happen. So most people think the will controls everything at death, okay? It doesn't. Maybe that was true many years and years and years ago, but now our world is filled with will substitutes, okay? Most of our assets and many of our assets are in the form of a will substitute. Now, what's a will substitute? A will substitute is an asset that passes by operation of law to a joint owner or a designated beneficiary. Okay. It avoids probate. Okay. Anybody here want to name a few will substitutes? And they're all around us. All around us. Come on. I know it's 6 o'clock now, everybody. Come on, let's hear some will substitutes out there. Yes, sir. Taunton Trust, yes. An ITF account in trust for? Anybody else? Yeah. Yes, thank you. Life insurance is a big will substitute because you name a beneficiary. How can I change that life insurance into a regular probate asset? By naming the estate, that's right. Again, keep in mind about the linking of the assets with your plan. Okay. Life insurance, Taunton Trust, what else? Yes, joint tenants property. JTWROS, joint tenants with rights of survivorship. Okay. POD, payable on death. TOD, transfer on death. And what about we're missing a big one out there, 2 big ones. Come on, 2 big ones. Everybody's saving, that's our hint, saving. Retirement accounts, right? Our retirement accounts, our IRAs, our pension plans, our 401ks, all have beneficiaries. So they should, and that should be part of your checkup to make sure you have beneficiaries. So if you don't have beneficiaries on your retirement accounts, sometimes the default can be the estate, and that's not a good thing for tax consequences because the estate, the account could be liquidated, accelerating all that income taxes that you never paid, and that's not a good thing. Okay, and the last thing I was thinking about, a tenancy by the entirety, right, for our real estate. And actually one more thing, and we'll talk about it in a little bit. And these are very, very popular in states such as California and Florida. In fact, I'll also say that they're pretty much the standard operating procedure. When you do an estate plan in certain states that are known to have kind of difficult or challenging probate systems, you go by the revocable living trust. Sometimes they call it a living trust, a revocable living trust, but that's a super will substitute. Okay. Assets that are titled in the name of the living trust on death pass to those folks without the intervention of the probate court. Okay, how easy is it to collect a will substitute? Generally very easy and quick, okay? That's why, there is a lot of popularity for having them. Generally, all you need to do is you present a death certificate. Sometimes they may ask you for a W-9 form, which is a kind of a confirmation of your tax identification number, your social security number. Sometimes they'll ask for an affidavit of domicile, which is signed or notarized. Generally, it's very quick and easy, okay? Yeah.
Aren't there laws though where if you have a bunch of these out there, your wife has to get a minimum if you're fairly giving them out to other people that you challenge?
Okay, the question is aren't there some assets out there that the spouse must have rights to it, we must get a waiver? There are certain types of retirement accounts that, yes, you must get a spousal waiver. Those are certain types of, I think, ERISA-type plans. And very often, if you're dealing with a prenuptial agreement or a postnuptial agreement, that's a section that's addressed that the spouses will agree to execute the necessary waivers so the person can give away those retirement accounts. But when it comes to payable on death or transfer on death or tenancy by the entirety, irrevocable trust, and the majority of them in life insurance, that's not going to be the case. Okay, so we have our property passing by will substitute. So what's left for property passing under the will? I kind of call it like our safety net or our orphan property. That is property where we don't know where it goes. We don't know where it goes because there's no joint owner or beneficiary designation, okay? So when I'm doing estate administration and people are coming in, I get a little teaser for the next program, I'm going to ask them for an inventory of assets. I'm going to say, okay, what are the assets and how they titled? And if you remember, I'm going to go notice our estate planning profile. Remember I asked how things are titled and beneficiaries? Because those assets will pass by operation of law, and then the assets that don't have beneficiaries will be then controlled by the will. Now, again, you really want to make sure that your assets are going to match your estate plan. And again, each state out there has its own separate probate system. And for all of our online viewers, one of my takeaways is get to know or understand your local probate system, because some states, they're known to be difficult. Some states, they're known not to be. And if they are difficult, very often you will see the use of will substitutes in irrevocable trust. I'll just say for our New York folks here in New York, I use them sometimes, okay? For many of my families in New York, I don't necessarily need to avoid probate because the probate system isn't necessarily that difficult or challenging, but I may want it for certain instances. So again, the important point to take away, make sure you coordinate your assets with your will. So let me give you an example, okay? I got married later in life and I started working out there, and I was working for an employer, and I had a 401k, and I named my sister as the beneficiary. Then years later, I got married, okay? So if I died, and my will says, Jill Miller, gives everything to my husband, and my husband comes running into the IRA people, okay? The will says, I give everything to my husband. What about everything don't you understand? Okay. Well, what are they going to do? They're going to look at the beneficiary designation, and they're going to say, sorry. Okay. Now, again, there are certain state law nuances here, but the point is really make sure when you're doing the estate plan, tell them get those beneficiary designations and know what they are. So step one is know what they are. Then after you do your plan, then update them accordingly. Okay. One other point on that example is, we'll touch on it. Yes, my husband has elective share rights, but we'll go kind of touch on that. That's going to have a whole lecture on elective share, and I do that in law school, but that kind of goes beyond the scope. But the point is, make sure you have your coordination. Another common question that clients ask me is, how often do I need to update my estate planning? And so what I tell them is like you go to your doctor you're supposed to go to your doctor every year for your checkup. Well, I tell them, go every 5 years. Give me a call every 5 years. Let's take off the old paperwork. Let's see if the people that you've named as executor are still people that you trust or around or capable, and your trustees, the guardians of your children, they still on your A list, you're still friendly with them or not, or have circumstances changed that made some of these people stale. I also talk about if there's a significant change in your financial circumstances, or if there's some big changes in the tax laws coming. I mean, they are now, it might be a time that is very, very busy for all of us, or there have been big changes. So now let's move on to our basic set of estate planning documents. First, we've got to start with the will. And I just want to talk about a couple components of the will that no matter whether you do a very sophisticated estate plan or a very simple one, you're going to want to see these items, okay? First, you're going to have the title. It's good to know what you're looking at, okay? And then the next part is like you're going to have like the introduction, and it contains your traditional revocation section. So it's going to say, name of the client, residing at wherever, publish and declare the following to my last will and testament, hereby revoking all wills and codicils heretofore made by me. You're going to want to see that revocation language in your opening section. Okay. Then typically, your typical pattern is you're going to start naming your fiduciaries. Who's your executor? Who's your trustee? Who's your guardian? Ask for successors. It's always good to have successors. Another part, you're going to see them all the will forms, a waiver of the bond. Okay. We want to make sure the bond is waived. What's the, many probate courts, if it's not in there, they can impose a bond. You see that in estate administration where people die without a will. And what's the purpose of it? It is to protect creditors and third parties if your administrator, your fiduciary, does something wrong. And they're not inexpensive, and it's a cost of the estate. So one of the things you want to do is, we don't need a bond. We don't need to spend that money. Okay. Again, you typically see that. Next, you see a direction to pay all your debts and funeral expenses. Then comes our who gets what, the disposition. I generally see the tangible personal property coming first. And there are reasons to have that separate. It becomes more important when you have more complicated estate plans, and there's some tax issues that are involved, which again goes beyond the scope. But traditionally, you're going to see the tangible personal property separated out, okay? Tangible things you can touch. Sometimes you'll see it lumped together, so I give all of my property this way, but I think it's just better to kind of take out the tangible personal property. Then the next, you're going to see your general bequest. Anybody remember that from law school, general bequest, what that means? That's our certain sum of money. I give $1,000 to my sister. I give $500 to the American Heart Association. Then the last part is the residuary estate. And one of the things I remember when I was first learning this stuff from law school, I don't know if you may still find this interesting, when I think about the residuary estate, it's kind of counterintuitive, isn't it? Because when I'm thinking about, oh, you're going to get the residuary of the dinner, of the pizza party. You're thinking like, oh, I'm going to get like a crust and some old soda, right? But really, in the estate planning world, the residuary is the good stuff. It's the bulk of the property. They're the main takers. So I always say it's kind of counterintuitive, okay? Then after we see who gets what, we're going to see the fiduciary powers section. Also, we want to see a tax allocation provision, who's going to be paying the taxes. And then we have our signature and our witness attestation provision. So our witness attestation is where our witnesses are saying this foregoing instrument has been signed, sealed, published, and declared in our presence by, as the last will and testament, the name of the client and whose request and whose presence and in the presence of each other. Thereupon subscribed our names as witnesses. And in this attestation clause, the use of those words is not random. They typically will dovetail your execution requirements for the will. So you're saying that. So basically, the witnesses are saying they're testing. Yeah, I saw this will was executed in accordance with state law. Okay. And then our last page of the will that we traditionally see is our self-proving affidavit, where we have the witnesses signing again with our notary, and that way, when the decedent has died, you don't have to necessarily track down the witnesses, and the will is self-proved. Okay. Now I would like to move on to, we touched on the revocable trust, and let's compare the revocable trust and pour-over will with our traditional, just straight-up estate plan. Again, There's many, revocable trusts are very, very popular. And again, in some states, there are, most our state plans come in that format. But let's compare the two. So our revocable living trust acts is a super will substitute. So it's designed to avoid probate, which in those states where they're very popular is a main driver. Okay, their probate system is usually costly, expensive, time-consuming, a headache. So you want to avoid that by having all of your assets in your revocable trust. Okay, and it also acts as what other document? Power of attorney. Okay, it also acts as a power of attorney. So meaning that when the assets are in the trust, and if you have someone as a co-trustee with you or a successor, and the person either becomes disabled or they're a co-trustee right now, they have the ability to manage the assets right now, right? So that you don't necessarily need to be schlepping down to all the different banks and brokerage accounts, brokerage firms to say, hey, I need to gain access to the funds and do some transactions. It's already set up that way. Okay. But you have your revocable trust, but you also have an important companion to it because it's one unit. It's the revocable trust with the pour-over will. You do not want to have one without the other. Okay? And what does the pour-over will function and do? It lives up to its name in that all this will does, it's generally only a couple pages, it pours over the assets that we didn't put in the living trust into the living trust. So it basically says, any assets that I haven't put in the living trust is going to be going to my trustees of my revocable living trust to be administered in accordance with the terms set forth therein. Okay? You want to have them both. Okay. Okay. So in the living trust, all of our dispositive provisions are in the trust. Where the will, in our traditional will, all the dispositive provisions, meaning who gets what, is in the will. And our pour-over will only kind of serves as like kind of a conduit, just to say whatever I didn't put in there is going to go in there. Okay. One of the most important parts when you're doing your revocable trust plan, and I can't emphasize it more, because if I want to say it's one of my 3 points, please remember, one of this is one of the points. It is important. One of the main objectives of the revocable living trust that adds value is to avoid probate. And if you don't fully fund the living trust with all of the assets, you're defeating the main purpose of the revocable trust to avoid probate. Okay. What does that mean? It means that every asset that the client has to be retitled in the name of the living trust. So instead of it being the Mary Smith bank account, it's the Mary Smith revocable trust, Mary Smith as trustee, or with Mary Smith and maybe Dave Smith as co-trustees. Okay. In many probate systems out there, you have the small estate, which is here in New York, it's $30,000. So if you have one account hanging out there that's $50,000, you may have triggered the full-blown probate, even though your main purpose was to avoid probate by having all of your assets in the living trust. So you have to go through all the assets and make sure they're in the living trust, or if they're traditional will substitutes, like maybe life insurance or retirement accounts, you have a beneficiary named. And then for tangible personal property, I will do an assignment of tangible personal property to the living trust. We have it all covered. And in our estate planning checkup every 5 years, so people are constantly opening accounts and closing accounts. Make sure that it's in there. This is a very tough lesson to learn, and I've seen it, and actually I've experienced it, where, an old estate plan, they meant, the road to hell is paved with good intentions. They meant to avoid probate. And they got the majority of the most expensive assets out there in the living trust. But they forgot a couple of accounts. And those accounts were above the threshold for small estates. And you got stuck with the full-blown probate system. And in this particular case in New York, it was a very big challenge indeed. And it's a challenge, and it doesn't necessarily have to be a challenge that you're concerned about a will contest. The process itself, it can be a challenge and an unnecessary waste of estate assets and lots of headaches for the clients and and for you as the practitioner. Okay. For the revocable living trust with the power of a will, I found that a really great use for it is my elderly widow with my adult grown children that may live all over the place. So you have your elderly widow, maybe she's, people eventually, the way life is, you're healthy and then you have like a slow decline. I mean, people now with medical technology, people will have, they'll be fine, and then they'll have some sort of emergency, and then their health level will drop, and then they'll kind of continue along until another, setback, they fall or something comes up. But people are able to, really their lives have been extended to, live a longer life, but may not have the full capacity. So you're seeing a lot more folks out there that are, having several years where they're not able, or either they're not able or they don't have the desire to manage their financial affairs. So we have our elderly widow, we have our adult children are living all over the place. With a power of attorney, they'd have to be flying in and making sure mom's home health aid is being paid for, and liquidating this account, and maybe just a power of attorney on one account, but what about the other? Maybe we're going to not need to sell the home because they have to move mom into an assisted living facility. If we have all of the assets in the living trust and it's all titled now, all set up, and then mom has a health setback, or we need to move some assets around, already done. People don't have to fly in. They're already recognized on the account. Makes things a lot easier. I've seen this plan used in this way, and it is a tremendous value to the clients, and the families really appreciate it. Okay, so that's our will and our living trust. Now let's talk what I call about the ancillary documents. Again, it's always good part of your basic estate plan. Our living will and healthcare proxy, okay? I know when I tell my clients, there's no wrong answers here. No wrong answers. Everybody has their own personal beliefs on what works for them, okay? So in the living will and healthcare proxy, that addresses your healthcare decisions. They're not financial decisions. It's your healthcare decisions. So our living will, I sometimes call that, kind of affectionately, my old trust and estates humor, the pull the plug document, where the person is saying, you know what, if it comes to time where I myself, are going to be in a terminal condition with no hope of recovery, I don't want to go on this way. I'm making a decision now when I have my full mind to say, please turn off the machines. And you generally, in New York, but you generally have a specific direction for nutrition and hydration, or rather the feeding tube, that you want that pulled as well. And sometimes you'll also see I have that in my documents, but I do want paid relief, lots of paid relief. Okay? So that's our living will. Now our healthcare proxy, that's separate. Okay? Sometimes in some forms you're going to see them combined, and some states may have them combined, but they're two separate decisions. And your healthcare proxy, you are naming somebody to make healthcare decisions for you if you can't make them. Okay? And again, it's always good to have an alternate. One common question that comes up, well, I want to name, both my children. I only name one person. Again, each state may be different, but I can only imagine that what happens if you name two children and one's saying, pull the plug, and the other person's saying, no, don't do that. So you really want to have, kind of one person. Just because you have one person doesn't mean, I tell them, that you can't have the family in the background saying, adding their thoughts and giving their input on what is the best thing to do. Okay. So that's your living will and healthcare proxy. Again, those are healthcare decisions, and they have nothing to do with financial. Okay. Power of attorney. Okay. That's your management of financial affairs during your lifetime. One of a big common mistake that I see out there, you have your power of attorney, someone, again, you have someone that's old and sick, they give someone power of attorney, they go on managing the person's financial affairs, the person dies, you got to keep using it. Is that okay?
No.
No, it's not okay, okay? The power of attorney dies with the person, okay? It's a very common mistake that I see. But then, what happens? What happens to all this stuff? Who takes over? The executor. It's the executor's job. Then our will comes to life if you have a irrevocable trust. You kind of, there's a continuum. Because the trustees are already there. You need to bring a successor, that's fine. But if you're co-trustee, you automatically just continue without missing a beat. Okay? So power of attorney ends at death. You need your executor. And if there is no will, you're going to have your administrator, or in some states, your personal representative. Okay. Power of attorney, two types generally. One is durable, the other is springing. Now, the durable traditionally is it's effective right now when you sign it. Okay. You're granting someone the power of attorney to be your agent, to manage your financial affairs during your lifetime, and it will survive your disability. So you sign it now, you lose your capacity, but it's still good. Okay, it's durable. Okay. Versus the springing power of attorney, and the way I always like to try to explain it is that it lives up to its name in that it springs into life the happening of an event, traditionally the person's disability. Okay. And the difference between the two, one, again, I'd say the durable is a lot more user-friendly and a lot easier to administer, because if it's durable, I'd say here in New York, most financial institutions are used to seeing them this way. Versus a springing power of attorney, we have to prove disability with a doctor's note generally, or maybe court-ordered proceeding that the person's deemed to be incapacitated. So that's going to take a lot longer to get through, because many financial institutions are concerned with being sued later on, right? So you bring in a springing power of attorney and like, Aunt Mary is disabled. They're like, I'm not releasing the funds to you until I get it checked by legal and make sure this doctor's note checks out possibly. The point is that there's more steps in the process. For our New York viewers, in New York, the new statutory major gifts rider, which is maybe not so new, and that's if you want to give gifts more than $500, it is a separate document that you must execute, where before was all in one. Now, if you want to give gifts more than $500, you have a separate document that you need to do. And even for our Lawline viewers, if you know of anybody that's in New York or clients move to New York, value added, let them know about this, about the statutory major gifts rider. And very interesting is the statutory major gifts rider. To execute it properly, guess what? It has almost the same formalities as a will. It has 2 witnesses and a notary. Whereas the actual power of attorney itself doesn't need that. Very interesting. And why is that? It's because a power of attorney, and I explained to the client, especially if you're using a durable, it could be a legal license to steal, can't it? Right? You give someone the power of attorney, you're trusting them, and the banks don't need to check with them. The person that's your agent, your attorney in fact, can present the power of attorney to the financial institution. If it's broad, do all the asset transfers, and the bank doesn't have to call them up, the principal up and say, it's all right, so I'm going to give that $1 million to your nephew. A power of attorney is a legal license to steal. And I think that is one of the motivations for the legislature here in New York to have the statutory major gifts rider, or anything over $500, you're going to need this separate document. And there's all kinds of bells and whistles and warnings. Warning, you can use this and they can undo your estate plan. But there is a value added to allowing for the gifting, and that is it leaves options open for potential Medicaid planning, and also, if someone is, say if you have an elderly client and they lose capacity, they've been giving, say, your annual exclusion gifts, which is $13,000 a year, to be able to continue with that, to continue the pattern if they're giving $13,000 a year for their grandchildren's account. If you don't have, you want to be able to discuss gifting, I think, with the clients and let them know the pitfalls and also the benefits of doing that. Okay. The next topic we're going to go over is our intestacy considerations. And one thing that I found interesting when I'm always reviewing the intestacy is that it's a lot broader than most people think. Most people think, well, the intestacy is where you die without a will, right? I always try to remember last will and testament. Testament is testate, there's a will, and intestacy is without a will. They can die without a valid will. They can have a will that fails, okay, that doesn't meet with the proper execution requirements. It fails for some reason, or it's thrown out for maybe for undue influence, or it's attacked and maybe go through intestacy that way. You can also have full or partial intestacy. Full is if you have nothing at all or it fails, but you can have partial intestacy as well. Say, for example, you do an estate plan that doesn't give everything away, okay? I've seen a plan where it says, okay, I give all my personal property, my CD collection and my iPod to my friend Tim, and I give, $4,000 to each of my nieces and nephews, signed, sealed, and delivered. Well, what about the residuary? Where's that? Right, you left it out. So there is your partial intestacy. Also, you can have a gift that fails. Okay, and I'm going to touch on old law school stuff, where the anti-lapse statute may not cover and provide a substitute gift. Say I have, maybe you have the residuary estate going to my friend Tim, and Tim predeceases the testator. We don't have an alternate. We don't know where it goes. We have the residuary clause, but it fails. Okay, so so the intestacy concept can be broader than what you think, and that's one of my main points. So if you have intestacy, and let's just kind of make for ease of discussion, our traditional intestacy, let's just say we die without any will at all. Okay, and in practice, that's what I see. Of all my almost 20 years of practice, more than 20 years, I guess, I don't really ever seen a partial intestacy. I mean, in law school I talk about it, and we have a case or two that we discuss. But in my practice, I've either seen it's at all or nothing. Either you come and you have nothing, or you have one. So that's where our state law kicks in. And each one of our online viewers, you should check with your state law and know what your intestacy rules are. And that's where your state legislature has decided who gets what, okay, based on who survived the decedent. And it traditionally favors our nuclear family, our spouse and our descendants, okay. And our intestacy is usually defined as a fraction plus a lump sum. So I'll just give you a couple examples. Here in New York, if our decedent died, survived by our typical nuclear family, our spouse and our children, our spouse will get our first $50,000 and the residue to the children. Let's compare that to the Uniform Probate Code. And the Uniform Probate Code is our uniform set of laws that some states adopt. And here, just to give a compare and contrast, our surviving spouse will get the entire estate under the intestacy rules if all of the children that are, if they're survived by children, if all the children are children of the decedent and the surviving spouse does not have any descendants that are not the decedents, okay? In other words, to say any testamentary distractions, okay? And this is an example of the conduit theory. And what I mean by the conduit theory is that when you're giving money to, say, your surviving spouse and it's your children, your blood children, I don't have to really necessarily worry that much about the accidental disinheritance because the parent is going to want to take care of their own, right? If you have your traditional nuclear family, the husband dies, give everything to the wife. That's one of my old vaudeville jokes, So you got to have a couple jokes in estate planning. Why do husbands die first? Because they want to. Okay. A couple jokes. All right. So you have your husband dying first, and your wife inherits everything, and then she later dies, and she doesn't want to take care of her own. Right? She doesn't have any other children from anybody else. She doesn't want to take care of her own. We're not she is a conduit for his property. It comes from her, through her, to the kids. Okay, so that's our example of our conduit theory. And there's a less chance of accidental disinheritance. So, but if we have our more modern family, where we have children from different marriages, our conduit theory doesn't apply anymore. And in our Uniform Probate Code, that changes as well. So where there's more testamentary distractions, I'm not going to go into the details, but the surviving spouse isn't going to get all the property. They're going to get a fraction, the lump sum plus the fraction. Again, why? Because the conduit theory is not served. Where we have, say, that the decedent has children that are not children of the spouse, or the spouse has children, that are not children of the decedent. Okay. Also, we're thinking about intestacy, and this is something that actually does come up once in a while. And if you guys can remember this, especially if you're doing an estate administration, here's one of the 3 things I'd like you to try to remember, is your family exemptions and allowances. Each state has their own way of describing that, but those are benefits that come right off the top of an estate. It's meant to go for your spouse or your children, and they're called different things in different states. We have the homestead allowance, we have the family exemption, In New York, we call it the exemption for the benefit of the family. Again, it comes off the top of the estate. In New York, it has different lists of different types of property, and that part is fulfilled under the different categories, everything from farm animals to cash, certain cash, personal property, tangible personal property that's in there. It's meant to give immediate financial relief to our surviving spouse and generally and also our descendants. Okay, and that is an important concept. That is in addition to the intestate share. Okay, it's in addition to. Okay, and when we talk about the elective share, these exemptions and property allowances are also in addition. Okay, so what does that mean at the end of the day? It means that between the family exemption and property allowances and our intestacy rules, which traditionally favor the nuclear family and generally the surviving spouse, very often we're going to see our small estates be covered by most of it, that the surviving spouse will take most, if not all, of our small estates between the exemptions and property allowances under the intestacy laws with the rules the way they're set up. Okay. All right. So what happens if there's no spouse or descendants? Then our state laws will then talk about, they start reaching out to further parts of the family. Then we start looking at parents, siblings, descendants of siblings, which is our nieces and nephews, grandparents, descendants of grandparents, or descendants of grandparents, aunts, uncles, and cousins. And then in our traditional estate, our intestate rules, there's going to be an end point that the state law is just going to stop at a certain point. It's not going to go on to another level of relatives. And at that point, then the property cheats to the estate. Okay, and it's different. Each state is different, and it's again important to check your own state laws to figure that out. What about if you have an intestacy? Who's going to be in charge? So your personal representative, the administrator, but who's going to do it? Who's going to do it? Generally, who's going to do it is generally going to follow who's going to get the most, which makes sense, right? Makes sense. So, and there's usually an order of priority on who's going to be served, who's the first right to serve as your administrator. Okay. Again, check your state laws for who that's going to be. Okay. Now let's talk about one of my favorite topics, our estate tax consideration and our basic planning structures. So a big part of estate planning is tax minimization. I mean, one of my other favorite jokes is like there's two systems of estate taxation. Okay, one for the informed and one for the uninformed. Okay, the uninformed always pay a lot more. Okay. Knowledge is power. And the one thing with estate planning is that if you are informed, there are lots of benefits and deductions and planning techniques that you can add value and save the family taxes if you choose to use them. If you don't use them, well, then you're going to pay more to the government or create unnecessary expenses. Okay. Again, a big part of our estate plan is to minimize taxes. And in our very complex estate tax regime right now, whereas the changing landscape, right, on the federal estate tax, you need to consider both the federal and the state estate tax systems. You have to look at both, okay? And for federal, it's challenging right now, because right now our estate tax exemption amount is $5 million, or actually $5,120,000 with the inflation adjustment, and that's good for how long? Good for the end of this year. So it's really, really busy for us right now, getting lots of those calls. You know what? I want to take advantage of my $5 million, lifetime exemption, because what happens January 1st, 2013? Our $5,120,000 exemption is going to drop to $1 million. Okay. Our current federal top estate tax rate is 35%, the lowest I've ever seen in my entire career. That is going to increase back to the top rate of 55%. Okay, if Congress does nothing. So right now, the only thing people are focusing on that I see is the election. So who knows what's going to happen? I've get lots of comments from clients. What do you think is going to happen? Is it going to go back to 3.5 million, or are they going to let the 5 million stay? What do you think is going to happen? And I basically say I've given up. I'm not making any bets. anymore. It was very interesting, just kind of a little anecdote. I came back from an ABA tax section meeting in Boston, and we're all standing and talking around, cocktail party conversation. So what do you think is going to happen with these state tax laws? And I just started saying, well, this person thinks one thing, and this person thinks another thing. And I'll tell you that the very senior practitioners that I have a lot of respect for, I talked to 12 different people, and I'm going to get 10 different ideas. So what do I say is that you got to have flexibility, and this is what I know now. And we'll know more in the future. Again, we have our federal system and our state system. So for our federal system, and focus on that, we have our federal estate tax exemption amount. And that amount is, and I usually say a parent, how much each parent can pass estate tax free. And I usually say to the children, but it could be for anybody. And I just say parent as an example. It could every individual decedent, and I'm just for examples, ease of illustration, I'm just going to say the $5 million instead of $5,120,000. So the $5 million, each decedent can give the $5 million to what I call non-spouse people. Okay, because when we give money to our property to our surviving spouse, so long as he or she is a U.S. citizen, we get the unlimited marital deduction. One really important note here is our estate tax exemption amount, it eliminates the estate tax. Compare that to the unlimited marital deduction, which defers the estate tax until the surviving spouse's death. Okay, really, really important. Okay, so another important part of the federal estate tax exemption amount, and I'll just mention it, and then we're going to be stopping for a break, is the concept of portability. Okay, I used to have my favorite tagline, use it or lose it, meaning that you have your federal estate tax exemption amount, and if you don't use it by setting up your bypass trust, your estate tax shelter trust, or your family trust, which is different names for the same concept, you lose it. Okay, you can't, if you don't use it on the first spouse's death, on the surviving spouse's death, say, oh, well, when my husband died, everything went to me and I didn't use it, so I want to have his estate tax exemption and my estate tax exemption amount. So didn't work, okay? But we have this concept of portability now, where it is for federal purposes only, make sure you pay attention to that, for federal purposes only. Now, I'm familiar with some of the states, not all of the states out there. I know New York doesn't have portability. I know New Jersey doesn't have portability. That's on the old use it or lose it. The concept of portability is that, yes, on the first spouse's death, for the federal concept of portability, if they don't use it, they can kind of bank it for the surviving spouse's death and add on to an unused exemption amount to the surviving spouse's death, okay? And you do that by filing an estate tax return and checking the box.
So, Ms. Miller, should life insurance be generally held outside of a revocable trust?
Okay, that's a really great question. It kind of goes back to coordinating our will substitutes with our will. So going back to earlier, a revocable trust is a super will substitute, and life insurance is traditionally a will substitute also. But you got to look at the underlying part of the estate plan. So my answer is, it depends. And it depends on what the person's estate plan is. So for example, if I have a very simple revocable trust that said it goes between husband and wife, and everything then goes to the surviving spouse, and then on the surviving spouse's death it goes to the kids, and we have no tax planning, and I have a life insurance policy that basically does the same thing, then I'm going to say that's okay. Or if you have, say, you have a single person, and that single person is having, say, a brother has a revocable living trust and leaves everything to the sister, and we have a life insurance policy that does the same thing, I would say that's okay. But very often we may have to really reconsider that. Because say we do an estate plan where we have minor children, we're going to be starting to go into the tax planning right now, and we want to be able to have assets that are available to put in our tax sheltered trust, the stuff in there to protect from estate tax. And if I don't have assets to put in those trusts, that can be a challenge. So when I have an estate plan where I'm going to want to make sure the assets are going to go, say, for my minor children, and I have life insurance that says on my death it goes to my minor children, and I have a will that says it goes in trust till they're 40, that's not okay. Because then I'm going to have a life insurance, which is traditionally probably a lot of money, going to the children, and they get it 18 years old. So the answer is it depends, and you got to look at the underlying details of your estate planning and objectives. I will also have one other note, because the question had revocable trust. Okay, this kind of goes beyond the scope of this lecture, but I think it is important to note that very often we're going to want to have life insurance in an irrevocable trust. Okay, because an irrevocable trust is a legitimate tax shelter, and if it's properly structured and funded, where the owner and the beneficiary of the life insurance policy is the life insurance trust, then that is estate tax free to the kids and the spouse, to everybody. Okay, and it's unlimited amount. So it's not like it's $1 million or $5 million, whatever your estate tax exemption amount is. If you set it up properly, you can have an unlimited amount of life insurance in the irrevocable life insurance trust, properly structured. Again, you have to have you have the premium payments. You got to have the premium payments covered by your annual gift tax exclusion. You're going to have rights of withdrawal. Real complicated stuff. It is covered a little bit in the estate planning booklet, so definitely check that out there for the irrevocable life insurance trust. But the takeaway is that when you think about life insurance, think about irrevocable life insurance trust, and that's really value added for the client. It could be worth its weight in gold when you save in estate taxes.
Great, thank you. The next question is, for clients that move to another state, do you recommend that choice of law provisions of revocable trusts be updated to reflect new state of residence, or retain original choice of law provisions for previous state of residence?
Okay, that's another really great question. You online viewers, you're getting some great questions. That's wonderful. So the question is, you move, do you update your revocable trust? Or I would even kind of expand that, do you update your estate plan? And I think there's two parts to that. One, I generally think that when you're moving states, you should update your estate planning documents. Not, because there's a lot of local law nuances that are important, and the traditional format of your living will, your healthcare proxy, and their power of attorney may be different. And this is not more of a legal issue, but more of a practical issue, because if your banks in New York City are used to seeing the Bloomberg form, and someone someone has a legal power of attorney in another state, and they bring it here, and they're not familiar with it, it's going to take a lot more time to process. There are also certain, local law differences that are respected in one state and then not another. One example is New York versus New Jersey. In New Jersey, we have the incorporation by reference doctrine, where you allow this list provision. So in my New Jersey wills, I could say I may have done a may have done a list where I have my personal property distributed, and then your personal property will say anything other than the list will go to this person. And then that will automatically incorporates that list by reference, and the last dated list will serve. Well, New York doesn't recognize that. So if you do move, you should update your documents. Now, specifically to the question about revocable trust, should you update for choice of law? What I would say, it depends on your state law. Okay, I mean, if you have a state law that's more friendly for your particular estate planning purposes in your family, then maybe when you're updating your entire estate plan, you would recognize the new law. If you're going to be updating your estate plan anyway, you would probably want to have the local law to avoid confusion as a practical matter.
Great. Another question from the online viewer is, Taunton trusts and POD are the same, but can you explain what these are?
Okay, so POD, payable on death, Taunton trust, transfer on death, ITF and trusts for, these are all types of will substitutes. What that means is that asset will pass automatically to that named person on death of the owner of the account. And collecting it is very easy. Like I talked about earlier, you just need a death certificate. This is a rainbow of will substitutes out there.
Great. Bequests to issue. What is the best way to shield such from their spouse?
Okay, great question, because we're going to go right into our estate planning. Bequest to issue, what's the best way to shield from that issue spouse? That's a common question that actually I have a lot of my families come ask me, oh, I like my child's significant other, but you never know, right? The 50% of marriages end in divorce, and so, what we talk about is trust. Because going back to my earlier example, if you give it outright to the person, it's theirs. Then they can, commingle it. They can add, their spouse can have access to it. It can be spent. But if you leave the money in trust for the descendants or for the child, then it's never never available to the spouse, and it's never put in necessarily in like the marital property if they should ever get divorced. So that is actually a traditional form of estate planning for children, is that we would leave the inheritance in trust. And then you talk about, do we want it in trust for life or do we want to end at a certain age? But trusts are natural asset protection planning vehicles and are very commonly used to keep the money for the benefit of the child, not only from a spouse, but other creditors too.
Great. This is the last question from an online viewer. If a same-sex couple owns a property as joint tenants with right of survivorship, purchased prior to the New York State changing law to allow marriage, and then they get married, does it change the status of the property ownership?
Okay, that is actually a great question. One thing what I do want to make note of is that New York issued, after the same-sex marriage came into play, a New York taxation of finance, and for all purposes, we're going to recognize this person as a spouse. So that means the unlimited marital reduction is available, and that's really great. For that particular, does it convert the property? I actually don't know that. I would have to look that up, but it's a great question. I would say that if they bought property now, it would be tenancy by the entirety. Whether it converts or not, I'm not sure. But it's a great question. Thanks for bringing it up.
Does anyone have any questions in the audience right now?
My last question is, I'm sorry,
No.
joint tenants with right of survivorship?
Yes, it was originally joint tenants with right of survivorship, and it was purchased prior to the New York State changing of the law. And then they got married, and does it change the status of the property ownership?
I would think not. Couldn't any two people own with with right of survivorship? So the answer would be no.
And I always just like to check, so
Great.
when in doubt, check.
I guess my addition to that would be if I had a property like the man, and then we got married afterwards, would it automatically become?
Right, I
No,
don't think so.
okay.
Yeah.
It's been
Okay. Great. Does anyone have any other questions? Okay. Thanks.
Okay, great. One last point, a New York point that was brought up, but I thought it was worth mentioning for our online viewers, and also kind of give a heads up for our New York people, but also as a heads up for our online folks, is that when this is a common challenge where our client will name the attorney to serve as the attorney draftsman to serve as the executor, and you have your attorney executor disclosure statement called the Putnam Affidavit in New York under SCPA 2307A, which from my knowledge is only in New York. So, and what that means is that if I call it, telling the client all these particular details. If you name the drafting lawyer as your executor, they have to sign a statement with its witness, basically saying that you were advised that any person that serves as an executor, including a lawyer, is entitled to a statutory commission, but they're also entitled to a reasonable legal fee. And there's some other particular provisions you must mention in this statement. And if you don't sign it, the commissions are automatically cut in half. The objective is to kind of like raise a red flag in front of the client, saying, hey, when you're naming a lawyer, your lawyer is also the executor. They're going to get 2 fees here, because the executor's commission is what it is under state law, and then who are they going to hire to do the estate work? Hire themselves. So they're going to have 2 different hats and get 2 different fees. And if you don't have that signed, then the commission is going to be cut in half. So I think that's a good point to mention. I've yet to find out if other states have that, but it is from my knowledge, it's a unique thing in New York. And I actually have seen folks forget about the attorney executor affidavit, and the commissions are cut in half, and the courts do look at it, do look for it. So let's go back on the summary of federal estate tax systems. We talked about portability for the federal, and that is going to be expiring at the end of this year, that concept of use it or lose it. But New York still retains the concept of use it or lose it, and so does New Jersey. There is no concept of portability. So what I'm doing is we want to build in flexibility to your estate plan. So that way, on your first spouse's death, we want to take advantage of what the maximum amount can be that we can pass estate tax-free under federal and state tax laws. Now, the estate tax exemption amount is also different for states. Remember I said you have two systems. You have your federal system and you have your state system, and it's different. So New York, it's $1 million for the estate tax exemption amount. New Jersey is $675,000. In Florida, there's no there's no state estate tax. So you got to look at your local law to see what your system is. And so when you're doing an estate plan, flexibility is key, and you have to pay attention to both the federal and the state. Okay. So again, for New York and New Jersey, we're still on the use it or lose it system. And so that means when I'm doing my estate tax planning, I can't count on portability. Because first of all, it's expiring at the end of this year unless Congress extends it, and right now New York doesn't allow it, neither does New Jersey. So let's move now into the basics of a tax-efficient estate plan. And what that means, and again, going into our flexibility, we want to use the estate tax exemption amount. And the way I try to characterize it is that money's for the kids, or rather, your non-spouse beneficiaries, okay? Again, that means the property is estate tax-free as opposed to the deferral of the estate tax where it goes for the marital deduction. So a general will say on the first spouse's death, and I use this as a formula clause, that I want to pass the maximum amount that I can pass free both on state and federal estate tax. And I usually put it into the estate tax shelter trust, which you'll see that in the estate planning booklet, also called the bypass trust, or the credit shelter trust, or the family trust. Typically, it's a trust for the spouse and the descendants. We'll generally see the spouse as a co-trustee with a third party. I like to set it up, the surviving spouse with a disinterested third party, so be able to have full discretion and compared to themselves and descendants. You don't have to worry about potential adverse tax issues with discharging a legal obligation of support. Again, that's an estate tax concept which goes beyond the scope, but if you have a surviving spouse with a disinterested co-trustee, you have more flexibility. One thing, and then on the surviving spouse's death, because the estate tax shelter trust is for the surviving spouse's life, whatever is left in the trust will then generally go to your descendants, per stirpes and equal shares. And you can see this illustrated in a nice scheme on page 9 of the estate planning booklet. One important note is that, remember I said you're going to carve out the maximum amount you can pass free of state and federal estate tax? Well, there's time that passes between, hopefully a long time, or between the first spouse's death and the second spouse's death, right? So what's happening to those assets? They're growing, hopefully. If you invest in them right, they're growing. Important to know, whatever's in there is estate tax-free, not just what you originally put in there. So here's a great planning tip. So when we're in the estate administration phase and I'm trying to pick what assets should go in that estate tax shelter trust, because not only those assets that are in there be tax-free, whatever they grow to is also going to be estate tax-free. We want to pick those assets that are the most likely going to appreciate, okay? Because again, anything goes to the surviving spouse, unlimited marital deduction, all that appreciation is going to be taxed in the surviving spouse's death, because that's what's going to happen. Because again, the unlimited marital deduction defers the estate tax; it doesn't eliminate it. Okay, so again, that's good value added in planning, folks. When you're funding that credit shelter trust, pick those assets that has the highest likelihood to increase in value to benefit your family. Okay. Another important note for when I'm talking about our estate tax shelter trust, because I'm talking about, well, it's estate tax free. Oh, everybody's excited. Yeah, that's great. But don't get confused about income taxes. Don't think estate tax means all tax free. Your trust is a legal entity. Okay, a person files a 1040, a trust files a 1041. Same as an estate. all those assets are hopefully growing, okay, and they're throwing off income. Wherever that, there is income taxes on that income, okay? It is not tax-free, okay? So, and where the general rule is wherever that income lands is where it's going to be taxed, okay? So if the income is kept within the trust, it's taxed to the trust. If the income is distributed to the family, it's taxed to the individual family members. The people that get the income will receive a K-1, and those K-1s will be given to their accountant and be considered when they're doing their income tax return. A planning tip. The tax rates for a trust and an estate are generally compressed, meaning that you're going to be paying a higher rate a lot quicker if the money is kept in the trust or the estate. Okay? So generally speaking, there's a big incentive to distribute the income out to the beneficiaries because they could potentially be in lower rates, lower tax brackets. So here's a good planning tip to coordinate with the accountant when you're administering the trust to see what our beneficiaries' income tax rates are when you're distributing income, if there's some planning opportunities, especially if everybody gets along. And again, the terms of the trust will tell you who the permissible beneficiaries are. Obviously, if your trust beneficiaries are doing really, really well and they're the top income tax rate and it would be the same inside the trust, then you're not going to have the opportunity. But there is a potential there, and it's worthwhile to think about it, and that's a good way to potentially add value, to coordinate with the accountant on that. Okay. So we have our credit shelter trust. There's two options, okay? The first option is the way I was kind of talking about. On the first spouse's death, I direct that the maximum amount that I can pass free of state and federal estate tax be set aside and put in trust for the benefit of the surviving spouse and the descendants, okay? It doesn't have to be with the descendants too. Traditionally, that's the way I see it, surviving spouse and the descendants, where the spouse is the primary beneficiary. Again, on the surviving spouse's death, it goes to the children equal shares. So I'm directing it. I'm directing that amount be set aside. There's another option too, and that's disclaimer. It's a disclaimer trust. And it's in the estate planning booklet. It's part of the materials on page 11. And the way that works, and I kind of coined that as maximum flexibility. Okay? And the way that works is this. It looks like kind of like an I love you will, but you have this option. So the way it works is this. So the will says, on my death, husband says, on my death, all the assets go to my surviving spouse outright. However, the surviving spouse has the option within 9 months from date of death to set up the estate tax exemption amount, the trust, by filing a disclaimer, or in New York called a renunciation. Okay? Really key, it has to be within 9 months to be a qualified disclaimer under Internal Revenue Code, and it gives a lot of flexibility. So that, and many, again, you have to check your state's laws to make sure you follow those rules exactly, because they're generally they're big sticklers on that, not only on the format of the renunciation disclaimer, but certain provisions that need to go on in there, and the service, who you have to serve it on, and how you deliver the service, certain statements, like there's an affidavit of no consideration in New York that you have to file. Bottom line is, please check with your individual state's rules on their format of a renunciation disclaimer. And so there's generally very flexible. So everything goes to the spouse, and the spouse can say, you know what, I didn't want to give the full $1 million or $675, or I want to only give $500,000 because, you know what, I think I may need it, and I only feel comfortable giving away $500,000 in this trust. So then you can use the disclaimer and just give away $500,000. You can disclaim a certain account, a partial interest, individual stocks. So you have a lot of flexibility to kind of pick and choose what you're going to put in this disclaimer trust, the estate tax exemption trust. Okay. Again, don't forget the 9-month rule. You got to generally do it within 9 months. Now there are some exceptions if there's minors, but this kind of goes beyond the scope. But just keep that 9-month rule in your mind, okay? And that gives a lot of flexibility, especially in these changing landscape with the tax laws. What is the negative? There's always there's the positive. Oh, it's maximum flexibility. That's great. Why shouldn't we all do that? But there's also negative too, right? There's always, you got to pick up both ends of the stick. Negative, so you can remember when you do a will, most people are doing it now. They're thinking, but things get stale over time, right? You do it now and you may not be using it for another 10 or 20 years. What happens if our surviving spouse is incapacitated? Could take longer, could be a challenge. We're counting on the surviving spouse to do the disclaimer. What happens if, they not, 9 months can go by very quickly, and they, if someone dies, it could be a big tragedy, and they may not be able to deal with it, and they're like, you know what, I can't deal with this, and so the 9 months is gone, and now you've lost that opportunity. Another thing is that if you think you're going to want to set up the estate tax exemption trust and max it out at the max amount you can pass free of state and federal estate taxes, then why don't you just say that and avoid the legal fees to prepare all the renunciation work, right? Because it's not, it's not a 5-minute exercise. So these are the different thoughts. When you're deciding, should I go the carve out, directing, because I'm definitely needs it, or do I want to preserve options and give the surviving spouse the decision how much to give and what. Okay. So that's our estate tax exemption amount. And when you're looking at your traditional tax efficient estate plan, you have your estate tax exemption amount, and then you have your marital share. So we're going to talk about your married couple. And the marital share, again, that qualifies the unlimited marital deduction if it's outright, or you can put it in a trust, a marital trust. It's a special type of trust because you want it to qualify for the marital deduction, called a qualified terminal interest property under 2056 of the Internal Revenue Code, called a Q-tip trust. That is a traditional estate planning technique for your second marriage situation. So on the husband's death, carves out the family trust, the balance goes in the marital Q-tip trust. The surviving spouse must get all the income. Those are certain rules. They must get all the income. Only the spouse can be the beneficiary of this marital trust. You can't have anybody else. It can only be the spouse. And then for payments of principal, you have the option. You can give it or you don't have to give it. You can look to resources that the spouse has or you don't have to. Then on the surviving spouse's death, whatever's in there is taxed in her estate and then can go to the husband's children from the prior marriage. Okay. So it's traditionally used for our second marriage. So it can maintain the second wife's standard of living, and then whatever she isn't used will go back to the children. Okay. Because if we give it to her outright, remember what our old story? She can do whatever she wants with it, right? This way, it protects the children's inheritance. Okay. But you can use it also for other reasons. You don't always have to use it for our second marriage, because again, trusts are natural asset protection planning vehicles. So we can use it for our surviving spouse that has a challenge with managing their money. And we know some of those people. I will also say this as a form of asset protection planning for those opportunists out there. And unfortunately, I know a few stories, and I know a lot of people that know a few stories themselves. Maybe a lot of online viewers know of your share of your stories where you have, your husband died and you have your widow out there, and there's no crime to be lonely and alone. And all the relatives come out of the woodwork, or all these friends come in, and this person's alone, and they become friendly, and then they hit them up with their sob story about their needs and their grandchildren's needs and their own, their needs, and they get power of attorney. This person starts making gifts, and this can happen. I actually have a sad true story of a case that I learned about where that was an elderly lady living alone, and she entrusted her longtime friend that lived in her neighborhood that she knew for over 20 years to be her power of attorney, and the husband had left it to her outright, and then when the widow died, this person had power of attorney. We found out they had written checks to themselves. They had written checks for their children's business. They had written checks to their children, their spouses of their children, and a substantial amount of money was taken, and the money's gone, and you've bought yourself a lawsuit, and as it turns out, they never were able to get it back because you can't get, if the person's bankrupt and have no money, what are you going to do? But what's the answer there? The answer is, instead of doing it that way, have it in trust for the surviving spouse. Have someone that you trust. I always say the short form of trustee is trust. Have somebody watching. The surviving spouse is a co-trustee too, so they're not, disempowered. They can be a co-trustee also. But then you have another set of trusted eyes. Say, oh, there's a $1,000 gift going to the caretaker for her birthday. I don't know if I really want it. Does she really want to do that? May or may not. But you have that safety net, that check. I also like this plan, just generally for asset protection planning. If you have family members that you're concerned with being sued, traditionally doctors. So a lot of my doctor clients, I like to have everything going in trusts because trusts are natural asset protection planning vehicles. Okay. So again, there's nothing to do with second marriage, nothing to do with these opportunists out there. Just just a form of asset protection planning, okay? And it can be very much value added. I want to talk about an important note about our non-citizen spouses, okay? Really, really important. And this is another one of those things, one of those 3 things that I would love for you to remember in 6 months' time. Remember this: know the citizenship of your spouse, please, okay? Because special rules apply for our non-citizen spouses. And I want to be very clear to focus. It's not the decedent I'm thinking about. It's our surviving spouse. That's the key. Okay? Because the unlimited marital deduction is not available for our non-citizen spouses. Okay? What's the public policy behind this is that the government is concerned that our surviving spouse, who's not a U.S. citizen, is going to run off to their country, take all of their money with them, and the government's never going to get their estate tax. So they're going to tax now. Okay? Estate taxes are due within 9 months of date of death. Okay? And to kind of add to the challenge is that jointly held assets between husband and wife, if you're a U.S. citizen, if the spouse is a U.S. citizen, it's deemed 50-50. It's qualified joint interest property. It doesn't matter who gave contribution. Not for your non-citizen spouses, it isn't. It's these old rules where it says we're going to deem it to all the decedent's property except to the extent that you, non-citizen surviving spouse, can prove contribution. That way we increase the estate to increase potential taxes. So what is the solution to this? Thank goodness that there is a provision in the tax code for this payment of estate tax. Again, estate tax will be paid within 9 months of date of death. If you're non-citizen spouse, if you have a non-citizen surviving spouse, they're going to be paying it, which also means that you could be using your estate tax exemption amount, which is traditionally preserved for the children, for the spouse, if you don't want to do that. So we have what's called the Qualified Domestic Trust, or QDOT. We always have a lot of acronyms in estate planning, under 2056 capital A, okay? And if you follow those rules, this is a substitute marital deduction, a substitute marital deduction. It's a Q-tip with extra stuff. It has security provisions in there. There's certain provisions that you must have a U.S. trustee. This does go beyond the scope of our talk, but the point is you have the QDOT trust. This can be set up under your will, or it could be done after the fact if someone said, oh, I forgot to ask, and you found out the surviving spouse is not a U.S. citizen. You can do what's called a post-mortem QDOT trust. I actually did an article several years ago on the post-mortem QDOT trust and how to set it up. It's not, it is a lot harder after death than when you do it in a will. It's one of my favorite sayings, either pay now or pay later. Paying now meaning planning properly and putting the right provisions for the QDOT trust for your non-citizen spouse. Paying later, it's a lot more expensive. It is what it is. Okay. When you have the QDOT trust, a couple benefits. One, it qualifies for marital deduction, so you don't have that immediate payment of estate tax. Two, what you can do with this QDOT trust is you can allow time for the surviving spouse to become a U.S. citizen. And once they become a U.S. citizen, that QDOT trust can terminate and go outright to the surviving spouse without incurring any estate tax. Or you can convert that QDOT trust into a Q-tip trust. So that is a great option to have. Another important thing to note about the QDOT trust, I said, okay, you have the QDOT trust, you have your non-citizen spouse, great, you don't have to pay estate taxes within 9 months, wonderful. But then what happens if the spouse needs money from the trust? They take the money out, guess what comes out with it? The proportionate share of tax, estate tax. So remember that. And there's special tax returns that are due when you're doing your QDOT trust. Also important. I have seen challenges out there where when you're doing the estate administration phase, people don't ask if your surviving spouse is a U.S. citizen or not. You know, they may say, oh yeah, I've been in this country for 20 or 30 years. Does not mean they are a U.S. citizen. Please ask, okay? I've seen challenging situations, which didn't have to happen, where the attorney did the estate administration, just assumed that they were a U.S. citizen because they've been here for so long, checked the box of U.S. citizen, then you find out later they're not, okay? Not a great situation to be in, okay? Maybe you think if they, if they tell you they were born somewhere else, good question to ask. That's actually a part of my routine estate planning intake. You ask them. You ask the citizenship of both people. Okay. Again, bottom line here, important to note, there are detailed rules. It can be complicated. An ounce of prevention is worth a pound of cure. Okay. Better to know what the story is about your family than to find a difficult situation later. Okay. I want to now move on to a very important part of the estate planning process, and I would say in my typical standard estate planning meeting when I'm talking to people for about 2 hours, I spend a good 45, 50 minutes on this, and these are our non-tax considerations for our estate planning. And yes, I'm a tax lawyer, and yes, I want to minimize estate taxes, but there are a lot of parts out there that you can really add value and save your family a lot of headache and time and money. And in some cases, those non-tax considerations can be more important than the tax considerations. So one thing is know your local law, your local court processes. Okay, so like for example here in New York, in many situations my probate process is not a big deal, but in certain circumstances it can be more challenging, and in those situations I might want to structure a revocable living trust. So for example, if I have unknown heirs, I'm going to traditionally want to have I may want to have a revocable living trust, because if I have unknown heirs, I can avoid the cost of publication. Another use of revocable living trusts, because I want to avoid probate because of the local law nuances, is if I know there's going to be a will contest in New York, each of my intestate heirs has the right to object to my will. Okay, by right, it's a statutory right that I must get their waiver and consent. If I don't get their waiver and consent, then I have to serve them a citation to come and show up at surrogate's court and say why this will shouldn't be probated. I call it an invitation to a will contest. Okay, if you have everything by revocable living trust, I don't have to find out who the heirs are and ask for their waiver of consent or cite them if they're not going to be cooperative. I avoid that whole thing. The point is that each state has their own set of procedures and processes. Know what that is, because the way that process may affect your client's estate plan and their family and their objectives, may impact how you want to set up their estate plan. Do you want to do it by traditional will, or do you want to avoid the probate process through a living trust and other will substitutes? Okay. Asset protection planning. Okay. We talked about it earlier, but the scope is pretty broad. Are there concerns in the family about creditors? Are they in a business that they can be sued a lot? Divorce. One of the questions was, what happens if you have, you want to give the money to your child, but you don't want it to wind up to your child's spouse. They can get divorced. And then there's also remarriage as well. You leave. Nowadays it's not uncommon. You have a husband and wife that's been together for 30 years. One of them dies. The person doesn't want to be alone. They get remarried. Many states, the moment you say I do, certain property rights come about. Okay, unless you have a prenuptial agreement or a postnuptial agreement. And then what happens? So the wife dies early, leaves everything to the husband. Husband doesn't want to be alone. So, a lot of men are like that. Okay, they get remarried, 2 or 3 years, what I usually see. And what do most married couples do? Okay, they hold things jointly, right? Then he dies, leaving everything to wife number 2, and then who really benefits? The wife number 2's kids. They become the laughing heirs. They wind up walking away with a lot of the property where the children of the husband never got anything. Okay, so we want to maybe think about trusts, our Q-tip trusts. And I call that also the accidental disinheritance. Again, no one, like that second spouse didn't necessarily think they're going to, I'm going to cheat the children from the prior marriage. They didn't necessarily think that. But sometimes these things happen. You know, I always say there's no crime to be lonely and alone. You know, someone's elderly and alone, new friends are made, new relationships. They become dependent on the people, whether it's a caretaker or a friend or a neighbor. And when the person is, for that person and, taking them to the doctors and getting their groceries and being there 110%, and they have a loving and close relationship, our lonely and alone person may want to reward them and say, you've been really great. I'm so sorry to hear that your nephew is really sick. I'm going to take care of them in my estate planning documents. And you can see more of that. Maybe we want to think about protecting that through the use of trusts. So the asset protection planning, the accidental disinheritance. Also, very important point, consider potential conflicts of interest when you're thinking about your fiduciaries, your executors and trustees. Okay, I've seen lots of fights when they just say, okay, I'm going to name my second marriage spouse and my adult child from my prior relationship, and they're going to be the co-trustees of the Q-tip trust for her benefit, where she gets all of the income and payments of principal and standard of living. And then on her death, guess who's getting the money? He and his brother, right? So here's a spouse. Okay, I want some money to remodel the apartment, or I want to go on this great trip, or, I want to move from this apartment and buy a big house in Florida. And then the co-trustee, which is the adult son, you don't need that, because whatever she's spending, he's not going to get. So, I mean, and this is like a big example, but you can have conflicts like this on investment advisor. The son is always used this person for 30 years, and the surviving spouse has used this person, and they both think that person's best, and they can, like a little issue like that can really mushroom and create a lot of hard feelings and adversity, and when you have that, it means more legal fees and more hardship for the family. Naming, when you're doing the estate planning meeting, get into the relationships. Maybe I always ask them, how do people get along? I mean, you have to take it at face value, but if the response is, yeah, I want to name my 2 children as the co-executors, and they really don't have a great relationship, they don't really talk to each other, I don't know if I really want to do that. Okay, even if it's a 50-50 split, believe it or not, I have seen challenges where even though you're naming the 2 adult children and they have a bad relationship, very often it could be payback time. They could use this to create problems for each other. In situations like that, what do we think about? Maybe we get a corporate fiduciary. Okay, maybe we get a disinterested third party. Maybe we get a family friend. Maybe we get Uncle Joe, because we know if we name the 2 children, they're going to fight with each other. Okay, maybe we just pick one of them. Okay, along with that is the commissions. So this is a point that's often overlooked. The fiduciary commission generally is not a small amount of money, and if you have, say, 3 children and you're naming one, and you're silent on the commissions, and that child who's giving a lot of hard work and effort and no good deed goes unpunished, because no one ever says, oh, thank you for naming executive, this was really a great time. I usually get the opposite, oh my God, I never want to do this again. And even though I'm getting executive's commission, it's not worth it. Very often they're going to take it, like, wait a second, because an estate administration job, that's not a 5-week position. It could generally take 2.5 to 3 years or more, depending on if it's taxable or not, and if it's audited or not. And that person it's a significant amount of time and effort. They take time away from their family, from their life, from their job to do all of this, and the other siblings are out there and they're not doing anything, and they're going to take that $50,000 or $100,000 or $200,000, and that comes right off the top. And now we have treated children differently, and that could be a sore point, because the other children may think, you know what, you should have done this for free because, you know, Dad named you, you know, because you were best for job. You should do it for free for all of us. And then the other person's thinking, wait a second, you know, I miss all these soccer matches, and I've had all these lawyer meetings, and you know, so you can see that. So what I generally like to do is like to talk about the commissions. How do you want to handle it? Ask the question. Well, it depends on the state law. The question is it 3%, is it 1%? Check your state law. It'll tell you what it is, okay? But it's generally not an insignificant amount of money. At least in New York, it's not necessarily based on efforts, okay? I had a real life story. I had two executors of a will. It was a very large estate. One person was very elderly and had eyesight issues, and the other person was sharp as a tack. And you know, I always teased them that they could come in and work, you know, help me out and work as a second career sometime. The person was brilliant and attentive, and that person did all of the work and didn't take a commission because he didn't want to take money away from their sibling. And the co-executor, the surviving spouse, who was a spouse from a second spouse, took the entire thing. And it was a significant hundreds of thousands of dollars. He did all of it. She did nothing. She took it. He didn't. Fair? No, that's the law. Right? So have the conversation, find out what the people want, and address it. Okay. Another non-tax consideration to think about is, do we have an estate plan that is cutting out the legal heirs? Okay, again, the legal heirs are those people that would take under the intestacy rules if there was no estate plan. Because there may be some strategic and non-tax reasons to avoid probate and do a living trust or have everything bound up in will substitutes. Another non-tax reason, we talked about a little earlier, are disabled disabled children, or maybe children who need protection from themselves or their spouses, or bad decisions. You need to ask the questions, because we don't want to have money going to an adult disabled child that could knock them off their Medicaid benefits, which is based, again, on your individual states. Your children, can they handle money? Are they in good relationships? What's the business? Do you think they could potentially go bankrupt or be sued? Let's think about maybe having trust for them. Again, it has nothing to do with taxes. It has to do with what are those families' needs. Ask the questions. A note on charitable requests. Okay. In your estate plan, very often, I asked, do you wish to give anything to charity? Couple things there. One, lots of charities have very, very similar names. And they may have local branches versus national branches. So find out from the client exactly what they want. Okay. Sometimes they have a particular use, and just ask them for that as well. Is there a particular use that you want for that charitable gift? A good practice that I do, especially if I'm not necessarily familiar with a charity, go on the charity's website and get their official name, get their copy of their IRS determination letter, which confirms that they are a qualified charity and money going to them will qualify for the unlimited charitable deduction. I remember there are a couple cases in my casebook that I teach at Fordham, and where there was some litigation arguments about the testator wanted to give to charity X, but the lawyer kind of got it wrong a little bit and went to charity Y, and that charity Y actually exists even though the names are very similar, and there was litigation on who exactly gets that money. So, an ounce of prevention is a pound of cure, because sometimes the client themselves may be writing a check and it's just that that's the name that they go by. That may not be their official name. So I think it's worth it to get the actual name of that individual charity. Also, certain types of charitable bequests, I call split interest trusts. Like there's the charitable remainder trust, charitable lead trust, where you want to give money to both an individual and to a charity, and they're mixed together. One thing to note: there are only certain types of these charitable trusts that qualify for the unlimited charitable deduction, and it's in the Internal Revenue Code, and you really got to follow it, because if you don't follow it, it doesn't qualify. Okay, it has to meet certain, as charitable remainder annuity trust, a charitable remainder unit trust. You have to follow those strict standards, or you're not going to qualify. The IRS will value the charitable remainder interest at zero, and you'll get no charitable reduction. I'll give you an example. Trust says, on my death, I give $1 million to my friend Mary for her support and comfort, all income, any amounts of principal for support and comfort. On her death, it's going to go to my favorite charity, the American Heart Association. That charity does not qualify. That trust does not qualify as a qualified trust under the Internal Revenue Code. It's not a charity. It will not qualify for a charitable remainder annuity trust or unit trust or lead trust. And what that means is that because we don't know how much money the charity is ultimately going to get, because it's unlimited discretion to give money to her, the IRS isn't going to take a gamble and say, oh, it's $1 million, we'll give you 10%, we'll give you 15%. They're just going to value it zero, because there's no guarantee they're going to get anything. So make sure you know the rules. And if the clients insist on having a trust that way, let them know you're not going to get a charitable deduction. Okay. And then another non-tax consideration, which I've seen can really avoid some headaches down the road, is have a mechanism for your successor fiduciaries. Okay, because again, keep in mind, people write wills and they keep them around for years, for 10 years, for decades, and the people that you've named, 30 years ago, they may, died, disabled, you can't find them, and you say even if you have a list of 3 people, and you don't know who's next. So I always say it's a good habit to have a mechanism for a last acting fiduciary to appoint a successor, or maybe the beneficiaries can then appoint a successor, so that you always have some mechanism if you run out of people to appoint a successor. Because in the alternative, if there isn't anybody, your local system's going to kick in, your state law is going to kick in, and sometimes that may mean having to go to probate court and getting new people appointed. In New York, it can be a mission, okay, and it's not a $5 exercise. And meanwhile, if you've run out of trustees, there's nobody to write the check. Especially if, say, imagine you have a disabled, beneficiary or beneficiary that needs this money, and your last acting trustee dies in office, and there's no mechanism for a successor trustee. So it's going to be some real time before we can get somebody in there. And meanwhile, the person's bills aren't being paid. So really think about successors. And maybe, and if the estate is large enough, you might want to think about a corporate fiduciary as the fiduciary of last resort. So we have 3 or 4 family members or trusted friends, and if none of those people are around, we can't think of anybody. Maybe it might be time to ask for a trust company or a bank, because they have perpetual life. Okay, and then they'll always be there. Now there's always pros and cons to everything. There's great things about corporate fiduciaries, but there have been some criticisms also. There's you are dealing with an institution, you have to pay their fees, but I've seen mostly that it's a very good alternative, and it's well worth it. They're professionals, they know what they're doing, and they're going to play by the rules. Going back to their non-tax consideration, where a corporate fiduciary may be good is, say you want to name your Uncle Joe as the trustee of the child's trust, but what about their relationship? Your child, there's always a hole in their pocket whenever they get money. You know, as soon as they get $20 for their birthday gift, they're in the mall, oh, I want to get this, I want to get that, you know. And that's their personality type that they like to spend. And say the money's in the trust, and the beneficiary is saying, Uncle Joe, you know, I really want that new red BMW. Like all my friends in school have them, and it's just completely unfair that I'm driving this old Honda. You know, and they pressure and they ask. And now it puts Uncle Joe in the spot, especially if he has full discretion and he's like saying no. And then now you could put a strain on the relationship. If you have a corporate fiduciary and they're playing by the rules and there's set standards, it preserves a relationship. So that's maybe a reason why we might want, you know, a corporate fiduciary for some of our trustees to maybe preserve the family relationships. My last section here, before we, I guess, have time for questions, is I have add value and anticipate issues for the clients. When you're doing a client's estate plan, don't have them come in here and they're like making an order off of a restaurant drive-through. I heard about living trusts, or I heard about this, give me that. You know, I want this person executed, I want to give my money this way, without asking the why. Ask the why. Find out what their goals are. That's one of the first things I started. What are your estate planning goals? What's important to you? Very often, when they give you your goals and you start teasing it out in the conversation, getting to know them and their assets, there might be different ways to achieve their objectives. And that you can present those objectives and help them find the best objective the best method to meet their objective. Clients really like that. You know, you tease out what their objectives are, what's important to them, present them with options, point out the pros and cons of the different option, and then they're making a conscious decision on which of the two options you presented to them. I mean, I always tell the clients, my goal is that next year, you're going to remember about our estate planning, because it's not just me just talking to you, oh, you should have this, you should have that, I'll look at, you know, you have this level of wealth, you have this family, you should get this. But they're part of the process. They're actively selecting. It's a conversation. So they're going to remember why they picked it and why their plan looks the way it looks. Again, know your local probate system. And if your local probate system has certain challenges, be prepared or plan around them. And then one of the last points is, and kind of going back to the beginning, is understand, again, the difference between passing property by will and passing property by will substitute and integrating the plan. So I kind of look at that, and that's at the very end. Okay, we've done our estate plan, we have our credit shelter trust, say we have the Q-tip trust or an outright marital, depending on what the family looks like. And then we're going to now match our assets up to our plan, simply by titling. Like one of the questions is, do we want to have the life insurance? Who's the beneficiary of the life insurance? Are we going to name the estate as the beneficiary of the life insurance, so it goes into the will, get controlled by it, so it's available to fund the credit shelter trust and go into the marital trust to be protected? And if there's no spouse, it goes into the trust for the kids. Do we want to do that? Say we wanted to have, we have 3 children, but we had one child that maybe need a little bit more because they're financially not in as good a situation as the other 2. But our will, we wanted to make it look egalitarian, that everybody's treated equal. Maybe we use a little will substitute on the side, a little CD, $10,000 payable on death to the child that needs a little more. But the will looks like we're treating everybody equal. Say we have our credit shelter trust and it's carved out, it's the $1 million, he's in New York, but then our spouse says, you know what, I don't know if I really want to have all that money in the trust. Maybe I can use will substitutes, and on the first spouse's death, we only have enough money to fund it with $500,000 instead of $1 million. The point is that it's almost like a living estate plan that you can turn things on and off, right, by simply changing the beneficiary, deciding whether it's going to go in the will or it's transferred to the living trust or not. And that gives a lot of flexibility. Those are my last main point. Okay. If we have any time for questions, this is a good time to open it up for questions from any folks here or from our online viewers.
I do have one from an online viewer. As far as conflicts are concerned, can you represent someone on a will and then act as the executor and still inherit it as a family member where you would normally inherit it?
Can you, repeat that again?
Sure.
Okay.
As far as conflicts are concerned, can you represent someone on a will and then act as the executor and still inherit as a family member where you would normally inherit it?
Okay, so if the question is, if I'm a lawyer and a client comes to me and wants to give money to me as their lawyer, that's a no-no. That's a no-no. You don't ever want to do that. And in many states, that would be stricken, or could be some real problems. If, however, we have, like, say in my family, my husband says, I want you to draft a will for me, he's not going to go to somebody else. I can draft a will from him, and I'm going to serve as the executor, I'm going to be the main beneficiary. That would be okay. So I think that would probably, make sense and answer that question.
I understood the question to be as a family member attorney. So if, for example, my mom comes to me and asks me to draft the
Will for
will,
her.
could I take as a beneficiary as well as executing and having drafted the will?
Yes. That generally is not a problem. It's a natural disposition. It's a natural disposition, and I've seen it, so, and that has never been a problem. The challenge is, and this happened to a colleague of mine, is that you have a client, they have a close relationship over the years, and sometimes your professional relationship becomes more of a friendship, and they want to honor you in the will, and they say, I'd like you to still be my lawyer and my executor, but I'd like to give a gift to your daughter or to you. You don't want to be involved with that. You say, you know what, you have to have that drafted by somebody else. You have to have that drafted by somebody else. Any questions? Right.
I have another one from an online viewer.
Great.
What is one common pitfall that new attorneys taking on these type of cases should avoid?
A pitfall in estate planning? There's a couple pitfalls. I would say one thing, and this kind of goes through one of the handouts that we had, is on the estate planning organizer, not getting the details of your family. Know who the beneficiaries are, know what the assets are. Like, you could have a big malpractice issue, is that, a client comes to you, a newly admitted attorney, and they're worth, $20 million, and they come to you and you don't do an intake and you don't know their tax issues, and you do an estate plan that has no tax issues, or you do an estate plan for a surviving spouse with a married couple, and the marital trust doesn't qualify for the marital deduction under 2056, and now you've blown the marital deduction, and now you're having an unnecessary estate tax liability, or you may need a reformation. Same thing goes with a charitable trust. So you gotta be sensitive to the tax issues. An important note on that, and I kind of cover that in classes, liability for attorney draftsmen. Now, in New York, we've very much enjoyed not having that exposure because there's the doctrine of privity, and meaning that you have a relationship with the person that hires you, the client, and the family member, that's the beneficiary out there, that lack privity. So there was, for a very long time, there was no cause of action, but there was a recent case, and now the wall, the citadel of privity has a crack in it, and there is other states out there that do find negligence for drafting, attorney draftsmen, lawyers that fail to take into consideration, taxes, family members. Maybe they get the person's name wrong. Maybe they don't do a full intake on all of the children. I actually had a real life situation that just came up where you have to do a really careful intake on the family, and they're telling me what they want, and then I say, okay, let's hold here. Let's find out about your family. Were you married before? Do you have any children? Oh yeah, actually I do have a child, but I haven't spoken to them in 30 years. Oh, okay. Really important. I mean, the way this person presented themselves when they started talking, you'd never know there were any children. Oh, I don't have any children. And then you bring it up to, oh yes, no, they've cut it out of their mind. I've had a situation where you're doing the family intake and they're saying, I have 3 children. You know, here, this is the married couple comes, I have 3 children. We love them very much, very dearly. Then when you start getting the details, you find out these children are only children of one spouse, but not both. And the other spouse has not legally adopted them. They're stepchildren, but in their heart they consider themselves children. So that matters, and it needs to be addressed properly.
I have also another one.
Okay.
In addition to your program now, are there any other resources that you would suggest to reach out to better learn the subject?
On the research on, well, for estate planning, there are, I have to say, and I did this for myself when I was a newly appointed lawyer, really working out there, is there's some great CLE programs, I mean, like this, but your local law, the local bar associations, you know, to go as many programs as possible. I mean, and that's what I did. One thing that I did do that I thought was helpful is that, especially if you're newly admitted, you're not working, or maybe you're in between jobs, a lot of these programs may give, the bar association programs may give some scholarships or reduced amounts to attend the programs. For people that are interested in doing more complicated estate planning, people may think about going back and getting their LLM in tax, or in estate planning. I think the University of Miami does that. There's a lot of books out there. You can go online. There's not one in particular that I have a favorite, but I like joining the American Bar Association, the tax section, and the RIPETY section. Great programs, and also the local bars have had great programs too.
Great, and I just have a question myself. Like, what's one of the most extreme, I guess, cases that you've ever dealt with that just kind of I threw you for a loop, and how did you deal with that?
Oh, the most extreme cases. I mean, I actually have, one, it comes to mind, one really sad story about the lack of planning. And you really, if there's one thing that's a takeaway, put the time in to do the proper estate planning, get full information on the family, get full information on the assets, and talk about alternatives. And think in the future. When you're doing an estate plan, not only do I do it what's good for today, but with a window of 5 years. But what I try to explain to them, you can't think about doing an estate plan that's good for necessarily 30 years down the road. You really have to think about coming in every 5 years to do a checkup, because it's just too difficult to really project that far out in the future, and to try to attempt to do that is going to be very, very challenging. But what I did see is that when there is lack of planning, especially between husbands and wives, that you just automatically leave everything to the other without having provisions in trust for them to make sure it's locked in to go to the kids. And I've seen several situations where, you have the married couple, they were together for 40 years, they built up this huge estate, and they did simple wills. They could gone online or went to a stationery store, simple "I love you" will, saying, everything to you, my surviving spouse, and then and she says, on my death it goes to the kids in equal shares, or vice versa. She dies, and he gets remarried. You have property rights that immediately attach. They have, very often they buy a new home together, or they buy a second home, and now you're owning it as tenancy by the entirety. And then, he may do a will that leaves, all of it to her, and she says, "Don't worry, trust me, your kids are like my kids, we're like one big happy family, I'll totally take care of them." Well, she took care of them all right. After he died, once you give it outright, they can do whatever they want. And all the promises and nice, friendly conversations over the holidays don't mean anything. So, I've seen situations where, where money winds up going, that's the accidental disinheritance, to those people that were never intended to the detriment of those that, if you had, those that were intended, or if you had asked that person, what would you have wanted? And like, of course I would have wanted to take care of my grandchildren, or my grandchildren first before the children or the grandchildren of my second wife. So you have to do the thinking. And when you have a childless couple as well, think about the nieces and nephews. Do you want to bring it back to the family, so you really need to ask those questions and listen. Okay. Well, everybody, it was a pleasure. Thank you.